When someone dies in California and a trust becomes irrevocable, who's entitled to a copy of that trust? And who gets this elusive notice? What is a notice? Maybe your mom's deadbeat uncle, who's not getting anything from the trust, has asked for a copy of the trust. Are you required to give anything to him? We'll be answering all of those questions today. And before I dive in, I want to invite you to sign up for my free newsletter to receive timely legal tips and helpful community resources. So you might have a loved one who set up a revocable living trust and then they died. Typically, upon their death, their revocable trust becomes irrevocable. That means no one can change the terms of the trust. So now let's say you've been named a successor trustee. What do you need to provide and who do you need to provide it to? Well, first, there's something called a notice of irrevocability and change of trustee. This is found in section 16.061G of the Probate Code. Okay, now what's the California Probate Code? That's basically where the government has delineated what needs to happen to a trust, to wrap up a trust, or also during a probate administration, and it says a lot of other things too. In a notice of irrevocability, you have to share the identity of the settlor who died and when their trust was executed. Then you need to share the name, address, and phone number of the trustee, that would probably be you, and also the address where the trust is being administered. You also need to let them know the fact that they're entitled to a copy of the trust if they request it. So let me share a copy of a sample notice of irrevocability so you can kind of see how this works. So here's our sample notice. Mom, Anita Singh, set up the Anita Singh Family Trust. She signed it into law April 1st, 2011, and then she died on September 3rd, 2024. That's when the trust became irrevocable, and that's when her daughter Priya became sole trustee. So we have Priya's mailing address, and then we have the location where it's being administered, and I've put down our mailing address. So then it says we're required to send notice to them, and I'll say who the them is, who's entitled to this notice. But first I just wanted to let you know what the notice is, okay? Under the Probate Code, and then it has some really important language that's in bold. You're supposed to put it in bold. It says you may not bring an action to contest the trust more than 120 days from the date this notification by which the trustee is served upon you, or 60 days from the date on which you receive a copy of the terms of the trust. So if you're receiving this notice, this starts the statute of limitations ticking. So you can only contest the terms of the trust within 4 months after receiving the notice, or within 2 months after receiving the notice and a copy of the trust.
Hello, did you know that my mom helps people all the way through the state of California from top to bottom? You'll give her a call.
So who gets the notice? In Probate Code section 16061.7b, it says that all beneficiaries of the trust and all heirs of the settlor are entitled to a copy of the notice. So who's the beneficiary? That's somebody who's receiving stuff from the trust. So I want to give you an example. Let's say that mom died and she left $50,000 to your nephew, and then the rest of it is to be divided between you and your 2 siblings equally. That's pretty standard language. And the rest of it is to be divided as follows, okay? You have 3 siblings, so there's 4 of you, and 3 of you get everything split equally in thirds, and then the 4th, one sibling of yours has been estranged, and they don't get anything. So in that case, who would get notice? Well, your nephew gets notice because he's a beneficiary, even though it's a cash gift. Now, some attorneys take the position that cash gift, you only get the writing that describes the cash gift. We typically send a copy of the entire trust, but it's up to debate. So then your 2 siblings who are receiving money, they're beneficiaries, and they would get a copy of the notice. You don't have to send a copy of the notice to yourself, by the way, even though you're a beneficiary. Since you're a trustee, we assume that you know the information already. All right, but what about that sibling who's been estranged from you? Are they entitled to a copy? Yes, it's because they are an heir. So what is an heir? That's a person who would receive an inheritance from that person if it was intestate succession, if there was no trust at all. It's a list of people. So that would be a surviving spouse, if you have community property, since we are in California, or it would be your child, if you have any children, or grandchildren, okay? Then if you don't have any children or grandchildren, then it would go to your parents. If you don't have any parents, then it goes to your siblings, all right? And if you don't have any siblings, then it goes to your nieces and nephews. So that's the list, the order of heirs. So in this case, your mother had children, and so all 4 of you are heirs. 3 of you are also beneficiaries, but the 4th one, who's estranged and not receiving anything, is still an heir. So that sibling would be entitled to a copy of the notice. So you may choose to send a copy of the trust immediately, or you may not. Notice that you have to tell them that they're entitled to a copy of the trust. We usually suggest that you just send a copy of the trust because that shortens the statute of limitations, as you might have noticed, to 2 months. Whereas if you don't send a copy of the trust, they have 4 months to contest the trust, and they can still circle back to you and request a copy of the trust. So when is the trustee supposed to send out this notice of irrevocability? Usually it's 60 days after the death of the settlor. You might be thinking, oh no, we've missed that deadline. Well, happily, there really is no penalty if you send out that notice a little bit later. So now let's get back to that deadbeat uncle of yours. Let's say that mom's brother is demanding a copy of the trust. He thinks that mom told him that he was going to receive something. Do you need to give him a copy of the trust? Well, let's see. Okay, first, is he a beneficiary? No, he's not receiving anything. Is he an heir? No, he's not. Even though your estranged sibling is an heir because they're directly underneath your mom, your uncle wouldn't be entitled to anything unless there's no children or grandchildren or parents. Then it would go to your mom's sibling, to the uncle. So your uncle is not an heir in this situation either. So nope, he doesn't get a copy of the trust. Now, I want to note something from a drafting perspective. Sometimes people might leave $1 to the disinherited sibling or to the disinherited child. I say don't do that because you've made that person a beneficiary. And now they get a copy of the notice of irrevocability and a copy of the trust. And then also you have to distribute $1 to them during the trust administration process and show that they accepted it. Well, if somebody came to your doorstep who said, hey, your mom died and she left you $1, here's your $1. Do you think you'd take the $1 or would you slam the door in their face? Don't leave $1. Just say, this person isn't entitled to anything, and then they don't get anything. So if you have a family member who recently died and you need some help carrying out all of these probate code requirements, please reach out to our office and we would be happy to help. We also have other videos about the trust administration process, and I invite you to watch those videos.
Did you know that my mom has a monthly newsletter? Subscribe by clicking below.